Welcome to this webinar organized by the Center for Comparative and Public Law of the University of Hong Kong. I'm Chen, Associate Professor of Law at the University of Hong Kong, and I'll be chairing this seminar. Chief Justice Geoffrey Ma served as the second Chief Justice of the Hong Kong Special Administrative Region from September 2010 to January this year. This was a period in which Hong Kong society underwent momentous developments, some of which found their way to the courts. Today, we're pleased to have a panel of experts from the Faculty of Law of Hong Kong U to reflect on the public law legacy of Chief Justice Ma. We're pleased to have with us in speaking order, Professor Albert Chen, Chen Lan Yu Professor in Constitutional Law, Professor Po Jen Yap, Director of the Center for Comparative and Public Law, Professor Simon Young, Associate Dean of Research at the Faculty of Law, and Professor Johannes Chan, Honorary Senior Counsel and Professor Chair of Public Law. We are also very pleased to mention at this juncture that we're extremely honored that Chief Justice Ma is now an honorary professor at the Law Faculty of Hong Kong U. We are very privileged and honored to be able to be with colleagues with him. Before we begin, a word about the logistics. We will have a Q&A session after the panelists' presentations. If you wish to ask a question, please type your question in the Q&A box. You may do this anytime during the event. You may, if you wish, state your name and affiliation. We will direct as many questions as we can to the panelists during the Q&A session. So with this in mind, I think we are ready to begin. Shall we first invite Professor Albert Chen to speak to us on Central Hong Kong constitutional relations? Albert, please.
Thank you, Cora. As Cora has just mentioned, the period during which Ma CJ was CJ, the 10-year period, was a very important period in the development of the law relating to one country, two systems in Hong Kong. It was a very eventful period. As I reveal the major events, particularly those touching upon Hong Kong Central relationship and the operation of the political system and the challenges to public order in Hong Kong, we can see that the 10-year period began with the Congo case, the first case of judicial reference to the NPCSC under Article 158 of the Basic Law. Then there was a challenge to the election result of the Chief Executive C.Y. Leung, assuming office in 2012, and soon there was litigation to challenge the election result. Then there were several developments in the legislature, including filibuster, passing laws to prevent LegCo members resigning to trigger what they call a de facto referendum, and then the famous or infamous oath-taking incident after the 2016 election. There was a case in which it was argued that Article 158 of the Basic Law should itself be referred to the NPCSC for interpretation. Then, towards the end of this period, we have the Occupy Central movement, resulting in cases being prosecuted before the courts, and also the anti-extradition movement, during which the Chief Executive in Council enacted the anti-mask regulation under the Emergency Regulations Ordinance, which was immediately challenged in court. And towards the very end of this period, the Court of Final Appeal dealt with the Lai Chi-ying bail application under the National Security Law. So you can see that all these were very momentous events in the legal and constitutional history of the Hong Kong SAR, and it has been a challenging time for the courts. What I'll do is to review very briefly, since I've only got 15 minutes, a selection of major public law cases touching upon the Hong Kong-Central relationship, as well as matters which the central authorities have a legitimate interest in, such as the effective operation of Hong Kong's political system and the maintenance of public order in Hong Kong, and so on. So before I look at the CFA cases, I want to mention that, in fact, there are a few very important constitutional matters which were decided only by the lower courts and did not reach the CFA, such as the question of whether returning officers in electoral elections could disqualify candidates, the question of the legal status of the NPCSC decision on co-location, and there was also a very important matter which didn't reach the court at all, which was the banning under the Society's ordinance for reasons of national security of the Hong Kong National Party. So I will now show the members of the audience a chronological list of what I consider the 13 most significant politically significant cases decided during the term of office of Ma CJ. He was actually a judge in all of these cases except the first case, which was except the second case, the Congo case. He was not a member of the 5-member court in the Congo case, probably because his wife, Madam Justice Yuen, sat as a judge of the Court of Appeal, from which the case was appealed to the CFA. So just to refresh the memory of members of the audience about what were these 13 cases listed here in chronological order. December 2010, which was shortly before Ma CJ assumed office, the CFA decided the case, the Charles Mock case, which was concerned with legislation providing for a so-called finality clause. After electoral election, if an election petition was brought to challenge the result of the electoral election in any particular constituency, the decision of the Court of First Instance was said to be final, and there could be no channel of appeal to either the Court of Appeal or the Court of Final Appeal. So in this case, the court struck down this finality provision, saying that it did not pass the proportionality test. The legislation concerned restricted the function of the Court of Final Appeal as prescribed by the Basic Law as the Final Appeal Court. Then in the next year, 2011, we have the Congo case. This was a very, very important case, probably one of the 2 or 3 most important cases in this period decided by the CFA on Hong Kong Central relationship and on matters of political significance. As you know, the Court of Appeal actually decided the case in favor of FG Hemisphere. But the Ministry of Foreign Affairs of the Chinese government and its office in Hong Kong issued statements or letters, basically saying that Congo should be granted foreign sovereign immunity. So the majority of the Court of Final Appeal disagreed on the matter of substantive law. They disagreed with the majority in the Court of Appeal, but they also decided to make the first ever reference of relevant basic law articles to the NPCSC for interpretation, on the ground that they related to matters of foreign affairs They were articles in Chapter 2 of the Basic Law on the Hong Kong Central relationship. Then in the next year, 2012, we have the Chen Yunnan case. Now, in this case, the CFA only decided on the leave application, deciding not to grant leave to apply to appeal to the CFA. This case was concerned with corporate voting in the legislature in the functional constituencies. The applicant argued that the language of the Basic Law, the relevant Basic Law provisions, is such that only natural persons should be eligible to vote in both the geographical constituencies and the functional constituencies. This constitutional challenge to the electoral law failed actually before the two lower courts, and the CFA did not grant leave to appeal. In the same year, there was the case in which, as I mentioned, the election result of the CY Leung winning the CE election. The election result was challenged by another candidate in the CE election, Albert Ho. This case went to the Court of Final Appeal on 2 occasions, first in November 2012 and then subsequently in July 2013. In the first of the 2 decisions, the Court of Final Appeal affirmed the lower court's decision not to grant leave for judicial review of the CE election result, but the court granted leave to appeal on 2 questions. First was the relationship between judicial review proceedings and the election petition proceedings to challenge the result of the CE election. And the second question was whether the 7-day time limit for bringing an election petition after a CE election was unconstitutional, being too restrictive. So the question of the 2 questions were subsequently decided by the CFA in July 2013. Basically, the CFA disagreed with the Court of Appeal and upheld the constitutionality of the 7-day time limit for election petitions after a CE election. But it also said, disagreeing with the Court of Appeal, that persons other than the candidates in the CE election could bring judicial review proceedings to challenge the winning candidate assuming the office of the CE. But on the substance of the challenge, in fact, it was held in the first case that there was no merit in Albert Ho's and also another applicant, Leung Kok Hung's challenge of the election result. Okay, so then going back to 2013, we have the Villagers case, the so-called foreign domestic helpers case. As you know, that they try to claim that after residing in Hong Kong for 7 years, they could be eligible to apply for the right to vote in Hong Kong. And this challenge to the existing immigration law actually succeeded before the Court of First Instance, but the decision was reversed by the Court of Appeal, and the Court of Final Appeal affirmed the decision of the Court of Appeal. But what is interesting from our point of view is that in this case, the government argued that Article 158 of the Basic Law should itself be referred to the NPCSC for interpretation. As you know, Article 158 is the provision concerning the power of the NPCSC to interpret the Basic Law. And the reason why the government argued that it should be referred to the NPCSC for interpretation was that in 1999, the NPCSC promulgated its first ever interpretation of the Basic Law, and that interpretation actually touched upon some issues which relate to this foreign domestic helpers case. But you know, what the NPCSC said was considered as a kind of obiter dictum in a previous decision of the CFA. So, so the government was trying to say that, well, what the NPCSC said was not obiter, it was binding on the court. But the CFA managed to avoid the reference on the ground that even though the classification condition was satisfied, the Article 158 relating to the relationship between Hong Kong and the central authorities, but the necessity condition was not satisfied. There was no need to refer this provision to the NPCSC for interpretation, because the court found that there is in fact no inconsistency between the immigration legislation on the so-called ordinary residents of the foreign domestic helpers, or the lack of ordinary residents, and the provisions of the basic law. So there's no need for the government to rely on the NPCSC interpretation of 1999. Now we move on to 2014. There are two cases. The Leung Kwok Hong, one of the Leung Kwok Hong cases decided in 2014 was about filibuster in the LegCo. So this was the first decision, a very important decision of the CFA on the extent of the president's power to put an end to filibuster in LegCo. So basically, applying the principle which was established in previous cases, that the court would not intervene in the internal proceedings of the legislature, except in certain extraordinary circumstances where there was a clear violation of the Constitution. So applying this rule, non-intervention rule, the court upheld the president's power or the decision to put an end to the filibuster in this particular case. Later in the same year, we have the CU case. This was actually only a decision not to grant leave to appeal, where the applicant challenged again the constitutionality of the flag desecration law. As you will remember, the CFA under the Chief Justiceship of Andrew Lee had already decided the case in the Kong Siu case, in which the constitutionality of the flag desecration law was upheld. Now, it seems that 2015 and 16 were relatively quiet years as far as what I call these highly politically significant cases for the CFA are concerned. Then we come to 2017. 2017, we have two cases. Okay, the Kwok Chuk Kin case, in which an amendment to the LegCo ordinance for the purpose of not allowing LegCo members who resign from LegCo, not allowing them to run in the by-election for the purpose of filling the vacancies resulting from the resignation. So there was such a law. This law was passed because in 2010, several legislators resigned to trigger what they call de facto referendum on the question of political reform in Hong Kong. So the government was determined not to encourage or not to give any incentive for legislators in future to trigger any so-called de facto referendum. I think this is a very important decision. I think this is probably one of the 3 or 4 most important decisions of the CFA in this period, because basically it adopted some kind of political question doctrine, whether it was legitimate for the legislature to pass this law to deter legislators from resigning in order to trigger a de facto referendum was basically a political question or a question of political judgment. And on this matter, the court would accord a wide margin of appreciation or a high degree of deference to the legislature when applying the proportionality test on restriction to the right to be a candidate in national election. Later in this year, there's this well-known oath-taking case, the Waijing case. Two legislators, pro-Hong Kong independence legislators, took an oath, their oath in office in such a way as to fail to comply with the oath-taking requirement. And as we know, and I think Johannes probably discussed this case, the NPCSC intervened and issued an interpretation. Well, the CFA did not actually have to decide this case as in a full hearing. It simply decided to refuse to grant leave to appeal to the CFA, affirming the decisions of the Court of First Instance and the Court of Appeal. Basically, in deciding not to grant leave, basically it said that it was not reasonably arguable that the two legislators could be held not to have lost their seat. So the disqualification was clear, as the CFI pointed out in this case. Even if we don't apply the NPCSC interpretation, just applying the Oaths and Declarations Ordinance, the two legislators would already have to be disqualified because of failure to comply with the oath-taking requirement. Well, the court did talk about the nature and the effect of the NPCSC interpretation. I think some of my colleagues would think that, the court did not deal adequately with some of the theoretical issues arising from this interpretation, which is quite different from the previous interpretations in terms of its scope or its retroactive or non-retroactive effect. But I think these are rather academic matters. As a matter of substance, I don't think that there's any reasonable chance that the two legislators could regain their seats upon appeal to the CFA. So since time is running out, I'll go over these three recent cases more briefly, because you all know about them. The Wong Chi Fong case, in which the court actually reversed the decision, the sentencing decision of the Court of Appeal. But this case is also significant in that the court pronounced its position on the question of civil disobedience. Then the two most recent cases, the Kwok Wing Hang case on the constitutionality of the Emergency Regulations Ordinance and the anti-mask regulation. So we all know that in this case, the CFI decided the case in favor of Kwok Wing Hang and other pro-democracy legislators, but the decision was reversed by the Court of Appeal, and the CFA simply affirmed the decision of the Court of Appeal. Finally, the Laijing case. Now this was the case in which CJ Ma still said this was not the case in which the court actually held that the first instance decision on the grant of bail to Laijing was based on a legal mistake. This was a case in which the CFA decided to grant leave for the government to take this matter, to take the matter of the grant of bail to Laijing by the CFI to the CFA. It involves several difficult legal issues, which I don't have time to go into at this moment. But this is a very important case on the national security law. So this was the last major case in which CJ Ma participated in the Court of Final Appeal. Now, this is a list the table to show you how I would analyze these cases. So I analyzed them by looking at, firstly, whether the case, and then there are a total of 13 cases, okay? So we analyzed each of these cases according to four criterion. First, was it a case involving a difference of opinion between a CFA and a lower court? Now, in some cases, all three courts or all two courts which heard the case had the same opinion. So maybe in those cases, the law was quite clear and one party's position was hardly arguable. But you look at these tick cases, and there were 7 of them. In 4 of these cases, the CFA disagreed with the Court of Appeal, and in 3 of them, the CFA disagreed with the Court of First Instance. But the Court of Appeal disagreed with the Court of First Instance, and the CFA agreed with the Court of Appeal. So basically, you have 7 cases. So these 7 cases can be said to be cases which are more difficult, in which the decision can turn one way or the other, depending on how the courts interpreted the law or dealt with some gray area in the law. Constitutional judicial review of a law. So you see, among the 13 cases, 7 of them concern constitutional judicial review of legislation, or we can add the Waijing case, because in that case, and I think Chen is an expert on remedial interpretation, and it was argued by Waijing that without that there should be remedial interpretation of a provision which might be unconstitutional if not subject to remedial interpretation. This was the bail provision.
Hi, thank you very much, Albert. This is extremely fascinating. I'm very sorry to interrupt, but because of our time limits, I wonder if you could wrap up. Maybe
okay, I'll take 2 minutes to finish.
Yep, thank you. This is fascinating.
These last two columns. Finding of unconstitutionality of the government lost the case. So we look at all these cases from the point of view of whether there was a finding of unconstitutionality or whether the government lost the case. There were 2 cases, only 2 cases in this category. Finally, I also assessed the extent of the jurisprudential significance of the case. So cases in which I give 2 ticks are what I consider to be most significant jurisprudentially in terms of the innovation of the jurisprudence or the difficulty of the constitutional or legal issue decided by the court, or the importance of the principle decided by the court in terms of its future implications. So there are 7 cases in which I gave 2 ticks, but there are also a number of cases in which I gave 1 tick. So to wrap up, I would say that if we apply the spectrum of judicial restraint and judicial activism to these 13 cases as a whole, I would say that the Court of Final Appeal probably leaned on the side of judicial restraint rather than judicial activism. But this is an approach which, in fact, I personally agree with. And I will quote an article, quote one passage, 1 line in an article I wrote in 1997 after the Ma case. The judiciary's self-imposed jurisdictional limitations not only do not diminish their authority and the community's confidence in and respect for them, but enhance their legitimacy and public standing. Without such self-limitations, there are increased risks of the politicization of the judiciary and the law, which reduces their legitimacy, and of conflicts and struggles between the branches of government, which destabilize the system of constitutional rule of law. So that sentence was written in the context of the political question and the jurisdictional limit on the court. But I think it also applies generally to the attitude of judicial restraint versus judicial activism. So that's all I want to say at this stage. Thank you very much.
Thank you so much, Albert. That is absolutely fascinating. I wish we have all the time in the world, and I hope we'll be able to revisit some of your propositions in the Q&A session. But for now, we will have to move on. Our next speaker is Professor Po-Jen Yap, who will be speaking to us on constitutional rights. Professor Yap.
Good evening, everyone. So my topic today is on C.J. Ma's contribution to constitutional rights. In my presentation today, I will focus only on 6 most significant landmark decisions on constitutional rights that C.J. Ma authored. For this purpose, I will also include cases where there was only a singular court's opinion for which C.J. Ma took part in. 3 cases concern political rights, and 3 cases concern LGBT rights. But I believe that these 6 cases sum up C.J. Ma's judicial philosophy on constitutional rights. For the political rights cases, I believe we can see how C.J. Ma has engaged in what Harvard Law professor Cass Sunstein calls trimming. Trimming is a heuristic for judges to attend carefully to competing political positions and attempt to steer between the poles when reaching a political legal result. And judges trim either by striking a middle path or preserving what is most essential to competing reasonable positions so that political conflict is reduced and people who hold competing positions do not feel excluded by the outcome. In Laundering versus Albert Ho, the CFA upheld the constitutionality of the statutory restriction that restricted a failed candidate, Albert Ho's, in the CE election to only 7 days to lodge an election petition after the result was declared. In doing so, the CFA overruled the lower court's decision to read in a judicial discretion to extend time. In the lower court, the 7-day limit was deemed unconstitutional as the government could not discharge its burden of justify how this 7-day rule was proportionate. Notably, returns for election expenses in the C elections do not need to be lodged until 30 days after the publication of the result. And it will be well past the 7-day deadline before any illegal conduct could be discovered. But according to C.J. Ma, and I'm quoting here, elections involve political and policy considerations. The determination that 7 days is the appropriate limit for lodging of election petition is one that does involve considerations other than legal ones. A due margin of appreciation should be accorded. But perhaps in the most important part of the judgment, C.J. Ma then suggested an alternative mode of electoral redress for persons who are not candidates in the CE election and hence unaffected by this 7-day time bar. For them, he held that these people could still launch separate judicial review proceedings against the election result. In other words, while the candidates themselves were time barred after 7 days, their surrogates were free to seek JR and challenge the validity of the election after that. In my opinion, there's essentially no substantive difference in result between the lower court's position of allowing the court to exercise a discretion to extend the 7-day time bar and the CFA's position of authorizing third-party surrogates to seek leave to bring JR proceedings to litigate the very same electoral issue. But in ruling as it did, I believe the CFA reached a decision that upheld the impugned law, thereby avoiding a potential conflict with the government while also preserving its oversight over electoral matters. Number 2, in Kwok Chok Kin versus Secretary for Constitution, Military and Affairs, the CFA upheld a law that disqualifies a legislator from running in a by-election to fill a vacancy consequent on that member's resignation. The law was passed in 2012 after 5 pro-democracy lawmakers resigned from their GC seats to trigger a citywide by-election referendum. The focus of the electoral challenge centered on whether the electoral restriction was proportionate. The CFA and CJ Ma once again reaffirmed that where electoral laws involve concern and they involve political and policy consideration, a wider margin of appreciation must be accorded. And the court agreed that it was legitimate for the government to deter resignation with a view to trigger by-election, as it noted, this political exercise cost 126 million Hong Kong dollars in public expenditure. And this was a legitimate concern, according to the court. Interestingly, counsel for the applicant raised concern that this law was disproportionate because it also barred lawmakers who had resigned due to poor health but recovered in time for the by-election. But CJ Ma parried this concern away by stating that pursuant to Article 79(2) of the Basic Law, Sikh lawmakers would have a valid reason to be absent from the Legislative Council meetings and therefore would not have any reason to resign from office and could not be disqualified from office. This judicial maneuver extraordinarily neutralized Article 79(1) of the Basic Law, which authorized President of the LegCo to disqualify a LegCo member if she or he loses the ability to discharge his or her duties as a result of serious illness. It is noteworthy that the CFA made no mention of Article 79(1), let alone square its reading of Article 79(2) with Article 79(1). Third, the most significant law and order ruling, and one that implicates political rights, which you all know, would be the one decided recently and his last substantive ruling on the anti-mask case, right? In Kwok Win Hang, the CFA had to decide whether the chief executive in council can invoke the emergency regulations ordinance to make regulations on an occasion of public danger, and whether the prohibition of face covering regulation was constitutional. We are probably all more aware about the more conservative part of the judgment, right? As we all know, the CFA overturned the lower court's decision to invalidate the ban on facial covering even at lawful peaceful assemblies. For the CFA, it was proportionate to dampen the emboldening effect of facial coverings at all assemblies, since the desire for anonymity does not lie at the heart of the right to peaceful assembly. But what is more subtle and what is more innocuous is what the CFA did with the Emergency Regulations Ordinance. Notably, Section 22G of the ERO stipulates that regulations made by the CE may provide for amending any enactment, suspending the operation of any enactment. Section 24 of the ERO further provides that a regulation shall have effect notwithstanding anything inconsistent with anything contained in any enactment. The upshot of these two provisions is that the ERO on its face can allow the CE to pass regulations that override all rights in the Bill of Rights Ordinance. But the CFA neutralized the draconian effects of the ERO by ruling that any regulations enacted pursuant to the ERO must not restrict any fundamental rights protected under the ICCPR and BORO as guaranteed under Article 39 of the Basic Law, unless the regulations satisfy the prescribed by law and proportionality analysis. In short, pursuant to Article 39 of the Basic Law, the ERO cannot be used to override BORO. Notably, even in the Court of Appeal, the lower court, the CA only held that the ERO cannot override Section 5 of borough. Section 5 pertains to non-derogable rights during public emergencies. But for the CFA, the entire borough remains applicable. Right? Turning now to the other three rights which concern LGBT rights, and these we see again are landmark decisions decided by CJ Ma. For all court observers, we know that Ma CJ and the Ma Court has been very progressive on LGBT rights. In W, the CFA determined that a post-operative transsexual must have the constitutional right to marry in their acquired gender. Next, in QT, the CFA upended the Immigration Department's discriminatory practice of limiting spousal dependent visas to expatriates who were in heterosexual marriages and extended persons in same-sex civil partnerships equal access to these visas. Finally, in Leung Chun Kwong, the CFA ruled that it was unconstitutional for the civil service to deny spousal benefits to same-sex couples married overseas, and for the Inland Revenue to prohibit these same couples from electing for joint tax assessment. While the CFA accepted that the government was entitled to protect traditional family constituted by heterosexual marriage, the CFA was unable to accept the proposition that heterosexual marriage would be undermined by the extension of these benefits to same-sex married couples. Notably, in the last two cases, the CFA overruled Andrew Chung, Chief Judge, as he then was, inquiry into whether any of this extension would affect the core right of heterosexual marriage. This test, according to the CFA, and I quote here, is circular and subjective. So I think it's quite clear if we examine the six most landmark decisions handed down by CJ Ma on constitutional rights. I believe we can see that CJ Ma has bestowed upon Hong Kong a significant rights legacy, and he has reshaped Hong Kong's constitutional landscape for the better. Thank you.
Thank you so much, Pojan. It's very helpful. I thought it's very illuminating to look at the nuanced aspects of the judgments that you highlighted, and the application of Sunstein's judicial trimming framework for looking at the cases is also very illuminating. Thank you very much. Our next speaker is Professor Simon Young, who will speak to us on the criminal law jurisprudence of Geoffrey Ma.
Okay, thanks very much, Cora. I have a set of slides. I'm going to share my screen. Okay, I hope everyone can see can everyone see the slides? Okay. All right, so the criminal law caseload of the CFA, of course, is quite large. So I thought I would sort of step back a bit and try to put this presentation in the broader context of decision-making in criminal law cases by the CFA. And I thought I would begin by doing this sort of Lee Court versus Ma Court comparison, so a kind of a historical perspective, and begin with some overall statistics on criminal cases. If we just look at the total number of judgments, this is both civil and criminal, we see, of course, more judgments in the Lee Court, but of course, this has to be taken from the point of view of the period of the tenure. So Lee Court was 13 years, Ma Court 10.5 years. If you divide that out, then actually the Ma Court seems to be looking at deciding fewer cases per year just by a little bit. Now let's turn to the criminal law judgments. Interestingly, it seems like there are more criminal law judgments being decided. And in fact, on average, something like about one more criminal law judgment per year. And so the caseload is about 42% of the CFA caseload is criminal law cases. Now, what about decision making? A remarkable degree of similarity here. low number of dissents, 3 to 4%, low number of concurrences, 20%, and then high number of single reason judgments. So a lot of similarity and continuity between the two courts. Some other interesting statistics, the rights cases and criminal cases, again, remarkably similar. About 1/5 or 20%, 19-18% of the cases involve rights. Government win-loss, that's the last one actually, also remarkably similar. Government appeals, very similar. Government only appealing about 15% of the cases to the CFA. At least, of course, mind you, this is important to understand, this is in the context of leave being granted. And of course, the CFA controls all the leave decisions. And on the win-loss, it's still the case that if you are, as a defendant, granted leave, you have more than a 50% chance of winning. Let's look now more closely at decision-making in the criminal law judgments. Let's look firstly at the permanent judges. This is not including the Chief Justice. One important difference seems to be that the permanent judges in the Ma Court are writing a lot more of the criminal law decisions. So there's quite a substantial increase from 56% to 71% of the criminal law judgments. So if the permanent judges are writing more criminal law judgments, who is writing less? Then of course the MPJs are writing less. So the local or Hong Kong MPJs, half fewer of the criminal law judgments, and of course the overseas MPJs are also writing fewer judgments. My guess is as we sort of go further into the future, that high percentage of the permanent judges writing judgments will probably be high, if not continue to increase. But of course, mind you, we're down one permanent judge at the moment. So that burden might fall upon the local MPJs, or it may go back to the overseas MPJs. We'll have to wait and see. But we might not see a great surge of the permanent judges writing these judgments, but probably I think down the road, once we have another permanent judge, we'll probably see an increase in writing by the permanent judges. Now, what about the Chief Justice? Some interesting differences here. Starting with Lee CJ, presiding in about 2/3 of the criminal law judgments, writing a good number of judgments, 17%, very little concurrence, and of course no dissent. With Chief Justice Ma, we see presiding in a lot more cases, about 6% more, but writing a lot fewer judgments, 6% of the criminal law judgments. And also little concurrence, no dissent. Mind you, one interesting phenomenon that we saw with the Ma Court is, of course, judgments that are attributed to the court itself. So in fact, if you count those, there are about 8 of them. And of course, the Chief Justice presided in all of them. Then that would probably increase the figure of writing of judgments, assuming, of course, he played some part in the writing of the court judgments. So you didn't see that in the Lee Court. I think maybe there was one civil judgment where it was written by the court, but not in the criminal judgments. So let's turn now and to look more closely at the jurisprudence. Let's start with the judgments written by Lee himself. Now, as I said, there was only 6 of them. And I guess, frankly speaking, if you look at these judgments, none of them really particularly stick out as being significant, or I wouldn't say it represents any particular kind of legacy in criminal law judgments. He wrote so few of them. And in fact, if you look at the last 3, they're all written in the last year and a half, sort of around the time when it was announced that he would be leaving the court. So maybe he felt that he would, I don't know, write some more criminal law judgments. So the first 3 The Wang Yok-man case is perhaps the only interesting one to highlight that involved, of course, some electrical representatives, citizens radio, and there was a constitutional challenge. But of course, the court ducked the constitutional issue and was able to resolve it on statutory interpretation. The last case, Zhao Li Mei, you might say, reflects some mercy in the court. This individual sentenced to 20+ years imprisonment for drug trafficking, convicted twice, won 2 appeals. The question is, would there be a second retrial? And the court noticed there was evidence of a psychiatric impact of being imprisoned and enduring these multiple trials, and said that enough was enough. It was not in the interest to order another retrial. But I think it's more interesting actually to look at the 70-odd cases in which he presided over and to make some observations about those. Here's 6 sort of categories of cases that sort of stuck out for me. When one looks at the 70-odd cases, these are a few groups of cases that I think are of some importance and significance. The first category are the human rights cases, not too many of them. And what one sees, and I've made this observation before, even with the Lee Court, is there's very strong tendency to maintain common law standards, but a greater reluctance to try to extend those standards by way of constitutional rights. So you have strong cases on self-incrimination at common law. There's a great case on confession evidence, Peng Hu-san, which applies the UK House of Lords case of Mushtak, which says that you have to direct the jury about voluntariness and being sure that there's no oppression before you can apply the confession evidence. It's a greater safeguard for someone who has made a confession statement. Of course, there's another judgment that reaffirms Li Fo-king, which is the right of silence case. If you remain silent before the police, it can't be used against you at all. No adverse inference. Prosecutors can't make reference to it all in cross-examination. There's a case of Atta that reaffirms that. However, of course, at the same time, there's the constitutional cases. Christine Fong, which is the legislature protest at in the public gallery in the legislature, and also the other case involving ICAC powers to compel people to answer questions. Laws were upheld in those cases. It didn't take it any further in terms of constitutional rights. The second category of cases that I think are quite significant are the youth sentencing judgments. I think many of you are familiar with them. The Joshua Wong case, I think the other is the Sunny Learn case. They're actually quite significant about the sentencing of young people. We shouldn't take such a punitive approach. We have to emphasize rehabilitation and also reform of young people. I've cited these judgments in my own practice. I think they're really quite significant. And I think they do change how in previous cases, particularly in maybe drug trafficking cases where there are very strict tariffs, that when there's a young person involved, that you have to look at them in a different way. And I don't think the CFA judgments have fully trickled down to the lower courts yet. Third category are the money laundering cases. We saw quite a few of them. They started with 2 cases in 2014, and then there were 5 cases thereafter. The 2014 cases, I had some involvement in them. They showed the court looking at the law very closely. In fact, narrowing the mens rea, narrowing the definition of proceeds of an offense. But then thereafter, the court reaffirmed that it's a very wide offense. At the end of the day, it's an objective fault standard. You don't need to prove that the property is actually proceeds of crime. They reaffirmed that. They recently reaffirmed that willful blindness can be another way of thinking about knowledge in those cases. So there's a sort of a balanced approach, narrowing of some of the concepts, at least from the previous sort of lower courts approach, but still reaffirming that it's a wide offense. Fourth category are the mens rea cases. Here I'm thinking primarily about the presumption of mens rea, Kula Messine, Choi Wailong, which are great interpretation cases that ensure that fault is at the forefront when the mens rea elements are invisible or silent. But at the same time, the court, I wouldn't say, is an overly subjectivist court. When there are good policy reasons to stretch the law on mens rea, they do so. And so we see that with gross negligence, manslaughter, not following the lower court's approach to apply subjective foresight. We see it in the context of joint enterprise liability, where we follow the Australian approach, taking a wider approach. There was some recent news about this in the context of rioting. Number 5 are the corruption and bribery cases. I think following a similar pattern that we see with the Lee Court, where the court takes a very robust approach in upholding these laws. And in fact, perhaps maybe going too far. There seems to be a little bit of disquiet with a recent case involving a violin teacher, where they're obtaining a violin without disclosing a secret commission, whether that should be bribery. The court said, of course, it's bribery. There is, of course, then cases where the court really looks at the issues very, very carefully and allows sort of fairness to prevail. And I'm thinking, of course, the Donald Zhang case, where if you look at what actually happened with the jury acquitting him of bribery, and whether it was necessary to direct the juries differently with that possibility in mind on the misconduct offense, and the court saying you had to do so, and then quashing his conviction. But at the same time, they upheld the conspiracy to commit misconduct in public office, and I would say interpreted that offense quite broadly, showing that even before you take office, if you take money from someone, you could still be guilty of misconduct in public office, although from the point of view of conspiracy. Lastly, I want to mention the purposive interpretation cases. There are many of these. Again, nothing too new. We saw some of this in the Lee Court, but this is an area where maybe difficult to see as a kind of group of cases, because they all deal with sort of different offenses and different types of scenarios. But what I do see is some commonality where the court applies the purposive and contextual approach to interpreting criminal offenses, and in effect interprets the offense in a narrow way, and hence finds that individuals are not caught by the criminal offense. And I think they're actually very instructive. I think we have to study these cases very carefully, because they demonstrate a way in how you should interpret criminal offenses, and not give them too wide an ambit. And I'll just mention a few examples. There was the case, of course, the Waijing case about what does it mean to deliver a message by transmission, right? Is the citizens' radio sitting at a table broadcasting, does that come within that meaning? This court said no. There's the milk powder case. What does it mean to accompany personal baggage when you have 4 tins with you and you're carrying 2 for your spouse? Does that come within the exception? What does it mean to tamper a vehicle? What does it mean to use a vehicle? Displaying a poster? What does it mean to be a friend under the prison rules? And also access to a computer. What if it's authorized access or not unauthorized access? You're using your phone. And then, of course, the money laundering, having reasonable grounds to believe. All these cases are illustrative of the court applying a purposive approach. What was the purpose of this criminal offense? And then finding that it didn't go as far as the prosecutors argued that it went. So I'm going to stop here and then happy to discuss this further in the Q&A.
Thank you very much, Simon. That was a highly informative presentation. Our final speaker is Professor Johannes Chen, who will speak to us on judicial independence and judicial value choices. Professor Chen, please.
Yes, thank you, Cora. I look at the two questions here. One is judicial independence, and second, related questions of judicial value choice, which I argue that some of the cases cannot really be determined on legal principles, but is determined or heavily influenced by some hidden values which forms judicial values choice. I start off with the farewell speech of Judge Geoffrey Ma on the definition of judicial independence. I'll skip through a few slides here about the source of judicial independence, which are not controversial. I pay tribute to Chief Justice Ma that during his tenure, he has built up a strong judiciary that's faithful and conscientious in discharging their judicial duties and responsibilities. Chief Justice Ma has also demonstrated leadership at a particularly vibrant, if not also turbulent time, when great social and political changes took place in the community and where political fractions on both sides of the debate did not hold back from criticizing the judiciary in very blunt and occasionally offensive terms. Chief Justice Ma also stood out in his readiness to explain to the public on the meaning of the rule of law and to defend independence of the judiciary. And a final area is the relocation of the Chief CFA in his present address, which becomes a lasting and visible symbol of the rule of law. In a way, Chief Justice Ma demonstrates all the qualities of what one would have expected of a Chief Justice: integrity, courage, sensitivity, and a good sense of humor. On this part, I look at two issues. One is the appointment of overseas judges and diversity within the judiciary. And the second is increasing attacks on the judiciary. Following the footsteps of the first Chief Justice, Chief Justice Ma has successfully persuaded many distinguished overseas judges of the highest ranking from the UK, Australia, and Canada to serve on the CFA, including, ironically though, for the first time in the first 20 years of the CFA, 2 female overseas judges. It's nice to have the female judges, although it comes a bit late. He has also enhanced the diversity amongst the permanent judge at the CFA, as at one stage, 3 out of the 4 PJs came from the same barristers' chambers. The system of overseas judge, which has attracted some controversy, I think that system has served Hong Kong well. The overseas judges bring in a wealth of expertise, insights, wisdom, and experience to our courts, and they have contributed greatly to the quality of the CFA judgments. And international judiciary also demonstrate diversity and inclusion in our legal systems, and their presence boosts confidence in our legal system and is invaluable in maintaining Hong Kong's international legal reputation and its status as an international financial center. They also facilitate cross-fertilization of jurisprudence between Hong Kong and other common law jurisdictions. And not only that, we have been importing other leading cases from common law jurisdiction, our Court of Final Appeal is also exporting leading judgments to other common law jurisdictions. Recently, some people said that we don't need overseas judges to maintain our judicial independence, and it seems the only reason not to continue the system is nationalistic. Of course, judicial independence is not maintained just by the presence of overseas judges. On the other hand, no country that I am aware of has such a distinguished panel of overseas judges. And among the 14 existing overseas judges, there are no less than 5 former Chief Justices and Presidents of the High Court. They serve at the highest court of various jurisdictions, as well as international courts, such as the European Court of Human Rights. The list is impressive by any standard, and it is our privilege to have the best among the best. I would say it is difficult even to get one of them, let alone 14 of them. I'm sure some jurisdiction like Singapore would love to have this panel. They have set up an international commercial court with some very good judges, but still nowhere near our CFA. And if the system has served us well, why should we give it up? It is sad to see that we have given away many good things that Hong Kong is or could be proud of recently. You can get rid of things easily, but you will never be able to get it back. Some people also say, should the scope of recruitment be expanded to other jurisdictions? Of course, this is always a possibility, But bear in mind, most countries do not allow their judges to serve on the bench in another country. That's the reason why we don't have any US judges on the CFA panel. And in terms of eminence, no one will doubt UK, Canada, Australia, and New Zealand are among the leading common law jurisdictions. The other institutional issue is during his tenure, we have seen an acute shortage of judges, resulting in a long backlog of cases and increasingly longer listing time for cases to be heard. There's also a large number of deputy judges to try to solve the backlog. It is fine if this is just a temporary situation, but if it becomes a systemic issue, the rule of law could well be undermined. I think more could have been done with shortage of judges, and there is no reason why we should stop recruiting judges from other common law jurisdictions. The basic law expressly allow that, but it seems that we haven't been doing that for some time. During his tenure, we have also seen increasing attacks were made against the integrity and impartiality of judges. Personally, and highly offensive attacks were made against judges solely on the outcome of the basis. There were even threats against individual judges on their liberty. Now, public and rational discussions on the merit of any judgment, no matter how critical they are, must be permissible and encouraged. On the other hand, scurrilous abuses and baseless attacks at the judiciary are quite different because these attacks undermine public confidence in the judiciary. And Chief Justice Ma has to make statements on a number of occasions explaining how the judicial system works and the proper limits of criticism leveled against the judiciary. Most notably, in 2020, he has to issue an 18-page statement to defend the judiciary and judicial independence. And he said that it's detrimental to public confidence in administrative justice for criticisms that were made without proper grounds and reasons, that were misinformed, that were taken out of context, and that were based on the result of a case and not to one's liking. These are well said, and also because of judicial independence, judges could not defend themselves from baseless attack. And as guardian of public interest, the Secretary for Justice has a duty to defend the judiciary rather than leaving it to the Chief Justice to defend it on groundless political attacks at the judiciary. And it is said that this has not always happened in the past. And judicial independence is to be maintained by everyone, not just judges and lawyers. And the judiciary is the last bastion to protect our rights. If we destroy the judiciary, and when the devil turns around, where are we going to hide ourselves? From this, I turn to the other aspect of the topic. I have absolutely no doubt about the independence of our judiciary during Mr. Chief Justice Ma's tenure or at any other time. On the other hand, judicial independence doesn't mean that decisions could not be affected by things other than the law itself. I'm not saying that the judiciaries are affected or take into account political considerations, but nonetheless, there could be value choices which could influence the outcome. And the thesis here is, in many occasions, when the case reached the court of final appeal, the question is not really which side of the argument is more persuasive. Either side must have their merits, otherwise the case won't go to won't reach the court of final appeal. And the court is really making a choice between two equally convincing and possible arguments. And here we are also reminded of the famous Heisen test in determining how to balance between fundamental rights and other legitimate grounds for restrictions. And one of the benefits of the Heisen approach is said to be that it can clarify different aspects such as assessment and make value judgments more explicit. Indeed, in some cases, value judgments have been made more explicit, in others may not be as clear. And particularly when we look at how margin of discretions applied. I look at 5 cases, and some of which have already been touched upon by my colleagues. The first is the proper boundary for judicial intervention. The W case is the leading case, the transgender case. And the issues there turns on the definition of gender. Should it be defined by chromosome at birth? Or should that definition be changed because it was outdated? And for this purpose, who should make that decision? And this case has a major impact on subsequent LGBT case, as Pojan has already highlighted. And the court said that the prevailing views of the community on marriage were not relevant because this was inimical to the principle of fundamental rights to rely on the absence of majority consensus as a reason for rejecting a minority claims. And very strong language. But the interesting issue is, given that social morals are in issue, should the court defer the decision to the legislature? Indeed, if you look at the W case, from court of first instance to the court of final appeal, all 9 judges involved were sympathetic with the plight of the transsexuals. No one doubt about the hardship that they face. But 5 out of 9 judges, if we count the court of first instance, the 3 judges at the court of appeal, and the dissenting judge, Patrick Chen, on the court of final appeal, 5 out of 9 judges regard that changes are too drastic social changes that was beyond the role of the court and should be reserved for the legislature. So to lead or to follow, that's the questions. And this is a value choice. The majority of the CFA decides that they should lead rather than follow. But in so doing, Mr. Justice Ma has taken a rather unusual step in his judgment to set out a whole range of issues that the legislature has to address, such as what if the gender operations took place during a subsisting heterosexual marriage, then what happened to the other party of the marriage? Should surgical operation be necessary for recognizing a gender change? There's a whole range of issues that need to be addressed as a result of the judgment of the court, which again almost reinforce the issues that, is this a legal matter that should go to the legislature, or should it be a matter for the court? And in a way, the court was right. The majority was proved right because legislature subsequently was unable to reach consensus on the draft bill to address these issues. If they don't lead, the law will still be what we were 50 years ago. The second case, a number of my colleagues has already touched upon it, the Belligeos case, that is the foreign domestic helpers, whether they should regarded as having ordinary residence in Hong Kong so that they would at some stage be entitled to Hong Kong permanent residence status. The issue turns on the meaning of ordinary residence. The leading case is the Shah case, where Lord Scarman held that the meaning of ordinary residence means how one adopted ordinary voluntarily for settled purpose as a part of the regular order of one's life. And in this regard, immigration status or condition of stay would have little relevance to these questions. The Court of Final Appeal said that their stays are not ordinary, but extraordinary. And they point to these factors. The foreign domestic helpers were only allowed to enter to take up the job of foreign domestic helpers. They are not allowed to change employer during their employment. They must reside in employer's residence. The 2-year contracts upon its expiry, they must leave the jurisdiction. They must return to their place of origin before taking up a new contract. The employers pay for their return ticket upon expiry of contract. They cannot apply for the entry of their spouse or dependents to join them. But when we look at these are all immigration conditions. And how do these immigration conditions affect their ordinary order of life in Hong Kong? If we look at the judgment of the Court of First Instance of Mr. Justice Johnson Lam, as he then was, he decides in favor of the domestic helpers, and he take the point that they came here for work, and whilst here, their lives in Hong Kong forms part of their regular order of life. They are entitled to rest day. They could do whatever they wish on rest day, whether social, religious, or entertainment. This is no different from any other Hong Kong residents. They have working hours, long be that as may be, but still they have working hours, and beyond the working hours, they may pursue their own activities, even self-study if suitably arranged. Yes, they may not have independent dwelling places, but so are many Hong Kong residents, given the living conditions in Hong Kong, and in any event, that's irrelevant. Yes, they have to return to their place of origin. They may retain the link, but this is relevant to their intention to stay in Hong Kong permanently. It has nothing to do with whether their stay is ordinary, and whether they can apply for their spouse to join them again is irrelevant. Many expatriates work here and are separate from their family. Now, if we look at these two judgments, both judgments are possible and equally convincing. You can easily write a judgment in their favor. The choice is between two possibilities. But then the consequence, we can see the judgments of the Court of Final Appeal is that as imported workers, they are forever locked to Hong Kong, no matter how long they stay here. We want their service, but we don't want to treat them as equal. And we can dump them whenever we don't want them, notwithstanding their immense contribution to our economy. The line has been drawn. Domestic workers cannot claim equal treatment with other expatriate workers because they are domestic workers. One may ask, is it more important to protect long hair from having his hair cut in prison than to protect this vulnerable group who are under constant threat and even abuses? Does it affect or reflect a judicial values choice when it defers to the government's position as reflected in the law that it is legitimate to treat imported workers as an inferior class? How does equality before the law fit in? The next case, again, some of my colleagues have touched upon it. This is the Kwok Chuk Keen case, the by-election case. And all along, we have been thinking that only socio-economic rights, which involve allocation of resources, these are outside the expertise of the court. So the court should give a wide margin of appreciation. And in this case, the court extend it to pure political, which is the civil and political rights, the right to elections, on the grounds that electoral law involve political or policy considerations. And when there has been active political debate on the issues in the legislature, the court should give a wide margin of appreciation. And underlying, there are two different approaches. The Court of Final Appeals approach assumes, or underlying assumption, is that there is a problem of abuses of the electoral system. So the legislature has taken a measure to address these political problems. So the court should respect the choice of the legislature in tackling this problem, and a wider margin should be accorded. Now, how you define the issue is not entirely a legal issue. Is it an abuse of the electoral process? In what way is a prisoner's right to vote any less political than a resigned legislature's right to take part in a by-election? I would have thought that prisoners' right to vote is even more controversial, but the court has no difficulty of deciding that case. And the case has attracted some criticism, and Richard Clayton QC said it is not self-evident that a legislature who resigns to run in a by-election to promote political objective is guilty of an abuse. And he cites Theresa May's call for an early election to consolidate her position on Brexit. This happens, and this is not an abuse. Likewise, Madam Justice McLaughlin said in another case that the debate on an issue, full debate on an issue, does not transform it into a matter of philosophy, shielding it from full judicial scrutiny. The fact that it has been hotly and extensively debated in Parliament does not change the nature. And what the right to vote is fundamental to our democracy and cannot be lightly set aside. The limits on it are not deference, but deserve careful examination to ensure that the legislature's profit justification is supported by logic and common sense. How we define the problem itself, it determines the width of margin of appreciation, and that itself reflects a kind of values choice. The fourth case, again, my colleague has already touched on that, the Waijing case. This is the disqualification case. And what I'm interested in is the fifth interpretation. When the Court of Appeal embraced the fifth interpretation of the MPCSC, which was made in the course of the Court of First Instance adjudicating the case, and it immediately gives rise to an issue, is if the interpretation was made well after the event, would it have retrospective effect? And indeed, that was the ground that put forward to the CFA, that this is a question of great general and public importance, which the Court of Final Appeal rejects that. and where the Court of Final Appeal regarded that the retroactive effect of the NPCSC interpretation was a settled question. We won't have time to address these issues, but I have challenged whether that issue is really settled as such. Among other things, the Court of Final Appeal, as in the earlier case, has held that the interpretation is legislative in nature. And if it is legislative in nature, normally legislation does not operate retrospectively. And one can put forward a respectable argument to argue that at least it involves a great and general public importance, questions of great and general public importance. But the tacit acceptance that the NPCSC could interpret the basic law at any time and can exercise that power to effectively direct how the Hong Kong court should decide a question. And if the NPCSC gave an interpretation on the very subject matter that the court was to decide, and did it shortly before the court was to render a judgment, is it not clear that judicial independence is being threatened? Should it be subject to any kind of restraint? And would it be surprising that the court would find no question of general and public importance in such case? The last case is the case that, again, my colleagues has referred to, the ERO case. Here, I'm more interested in the anti-mask restrictions, which the Court of Final Appeal overruled, the Court of First Instance and Court of Appeal, and uphold the restrictions to wear masks even in lawful and peaceful assemblies. And on the ground of preventive measures, that it is justifiable to take preventive measures even when the assembly is entirely lawful and peaceful. And here, how to balance a right of peaceful assembly and the adoption not of actual or imminent violence, but purely preventive measures with probably not much evidence to suggest that it would turn into a violent assembly. And the court justifies the restrictions on the ground that the circumstances at the time of regulations call for this kind of restrictions. But when the circumstances that justify the introduction of the regulation no longer exist at the time when the Court of Final Appeal decided the matter, which was almost 1 year after the regulations came into effect. And questions which could be asked is, when we decide proportionality, should proportionality be determined only at the time of the introduction of the restrictive measures? Or in this particular case, when an emergency regulation is to be justified by the continuing exigency of the public danger, should the continuation of the restriction be justified on a continuous basis? The difficulty, of course, is once focus on a historical moment of time. And as time passes, when the emergency situation no longer exists, the regulation may still be there and could be used to suppress peaceful assembly in very different social settings. And we have seen historically a lot of emergency regulations last for ages. And the last set of emergency regulation lasts for 30 years. Before they were repealed, and a challenge against CE in Council, a refusal to withdraw the regulation is simply unrealistic. Also of interest is the court find that the restriction on the right to peaceful assembly were only minor and although it involved a right of freedom of expressions, and when people could be inhibited to express peaceful assembly, and if they have to expose themselves. A classic example, if they want to demonstrate to support LGBT and they are worried that people may recognize them as, or their employer may recognize them to support such a cause, there could be all sorts of legitimate reasons to deter people from participating, expressing their right, because they cannot remain anonymous. And nonetheless, again, this is another value choice. This is a minor restrictions of rights only, and there is a move from actual or imminent violence to purely speculative needs of prevention of the restrictions, and which has resulted in a situation which is pretty ironic, that the court is deciding on whether the restrictions of wearing masks is constitutional at a time when everyone in the court and everyone in Hong Kong is wearing masks. The outcome seems to be completely divorced from reality. which brings to my conclusion that in many constitutional cases, the court is really choosing between two possible legal positions. Which position to choose from could be affected, sometimes unconsciously, by the value choices of the court. And we have seen that in quite a number of politically sensitive cases, the extent of scrutiny by the court appears to be less rigorous than in other politically non-sensitive cases, as we compare the 5 cases, 4 versus the sexual preference cases. And the court may be more ready to side with the government, not as a result of political pressures, but as a result of value choice through deference. So this is not to say that the court should side with public sentiment, nor am I suggesting the court is not independent. I'm very clear that I have full confidence the court is independent, but at the same time, the court may have to be aware of its own value choices. And the legitimacy of the judiciary rests on public confidence. If the court make decisions that are so divorced from public values, or giving excessive deference to government's decisions, or adopting a lower level of scrutiny against draconian provisions, resulting in rationalization of or lending legitimacy to a draconian regime, the public will lose confidence in independence. And judicial independence has to be upheld and has to be manifestly be seen to be upheld. Thank you.
Thank you very much, Johannes, for an incredibly rich and thought-provoking presentation. We now have about 20 minutes for question Q&A. In the interest of time, I suggest that I first throw all the questions out. I think there are a total of 5 questions, and I'll then invite each speaker to give short responses to the questions, to whatever question which you feel comfortable answering. So the first question is on the national security law. It's not directed at a particular speaker. The question is, how might the national security law affect the public law legacy left behind by Geoffrey Ma? The second question relates to interpretative approaches. Again, it's not directed at any particular speakers. The question is, are there any similarities or differences between the interpretative approaches adopted by the Lee Court and the Ma Court? And the third question, also from a member of the audience, and again, not directed at any particular speaker, is given the increasing interferences from Beijing, the NPC or the NPCSC making decisions that may or may not be grounded in the basic law, what is the likelihood of the legacy of Chief Justice Ma, especially in terms of rights protection and Central Hong Kong relationship, remaining valid? So to what extent his legacy will be harmed or compromised by the fact that Beijing is increasingly assertive in making decisions? And finally, just 2 very quick comments of my own. I think a theme that has emerged from a number of the presentations is that there seems to be a bifurcation in approaches in the Ma Court, in the sense that constitutional rights are treated with more judicial rigor, whereas so-called political cases, but in fact they are really politically sensitive cases, are treated with less judicial scrutiny. I wonder how might that impact on the legitimacy of the court? Albert suggested in his presentation that being restrained in politically sensitive cases might actually enhance, it's the best way to protect the legitimacy of the court. But to what extent is this incoherent approach to rights scrutiny or Central Hong Kong affairs, to what extent does this also harm the legitimacy of the court, given that it's quite ironic that on the one hand, the court claims to be a guardian of equality in, say, gender or LGBT rights cases, but on the other hand, when it comes to sensitive cases, they deviate from that approach. So they themselves are perpetuating some kind of inequality. So that's one comment of mine. The other the other 2 comments. One is for Simon. I wonder, Simon, and for criminal law cases, do you similarly notice? Do you also notice a sort of a bifurcation between politically sensitive cases and non-sensitive cases? And also, I think the perception at least from non-lawyers, I think, is that a lot has been happening in criminal law, but in the lower courts in the past couple of years, so in the magistracies at the district court level and probably at the Court of Appeal level, but not at the Court of Final Appeal. So I guess my question is this due to the very nature of criminal law disputes, meaning that a lot of them simply can't find their way to the Court of Final Appeal? Or do you think there is more the CFA can do in terms of playing a greater role in shaping the criminal law jurisprudence in these politically sensitive cases? And finally, to Johannes, value choice, value judgments, that's such an important topic. And I just wonder if you have any thoughts on how the court could make these difficult value choices, given that society is so polarized right now. So either way, their value judgment could be justified by public opinion, given that society is so polarized. I'll now leave it to speakers. Perhaps Albert or Pojan, maybe you can speak first if you're ready.
Albert, do you want to speak first or I'll start? I think, Albert, you're muted.
Yeah. Why don't you start first?
Okay, Pojan, thank you.
Okay, I'll just answer the two questions. One's on the NSL, right? In my opinion, right, if the court disagree with the government's position on the NSL, they have three ways of dealing with it. One is to declare that the NSL is unconstitutional, but we know that's not going to happen. That will lead to a reversal. The second way, what the courts would do is to say that, you know, the NSL has to be read with other parts of the basic law. So in a way, it's some kind of finding harmonization, right? And the third possibility is for the court to engage in a pure exercise of statutory construction. So they merely just interpret the NSL. And often enough, regardless of which model you use, the substantive result might be the same. Because we have seen under the Ma Court, the use of statutory interpretation to achieve more rights-friendly result. Like what is a friend, as Simon mentioned, right? So I think it's possible that, you know, if the courts avoid striking down the NSL, there are other ways that are more dialogic, more palatable of enhancing rights under an NSL regime. And the second question I think I would answer is on the jurisprudential difference between the Lee Court and the Ma Court. This is debatable, but I think formally speaking, I think the Ma Court probably most would agree is that it is not as liberal or activist on the right of a vote. I think that would be a fair suggestion, right? So Valijos and the case of Gutierrez, although they concern different issues, but I do not think that, you know, the Ma Court would have decided Ng Ka Ling and Chong Fong Yun the same way. And possibly, and this is just hazarding a guess, right, is if you look at who was the senior counsel leading the government's claim in Ng Ka Ling, it was Geoffrey Ma SC. And who was his junior counsel? Joseph Falk SC, Joseph Falk as he then was. Who was the senior counsel leading the government's claim in Chong Fong Yun? Joseph Falk SC as he then was. So I would say that I think, right, that the Ma Court, generally speaking, may be a little more sanguine about the government's concerns in the right of a vote.
Albert?
I'll respond to some of the points which have been raised. First, the NSL. I think, as I mentioned, actually just CJ Ma participated in deciding the leave application case in the Waijing bail case. So that case is actually quite significant, even though it's not as significant as the subsequent decision of the CFA on the mistake made by the lower court in deciding whether to grant bail or not. So as for the future, I think the decision of the CFA in the bail case, I mean the second case after the leave application, the decision is highly significant because it basically says that where the NSL provisions are clear, the court will give effect to those provisions and will not apply the so-called remedial interpretation. The court actually would refrain from any constitutional review of provisions in the NSL on the basis of the basic law or the ICCPR or the Bill of Rights. So where provisions are clear, the court will definitely give effect to them. But then the question is, what if the provisions are not clear? In the Waijing case, the CFA thought that the provision on bail or not granting bail is quite clear. So there's no need to apply any particular interpretive approach, or remedial or whatever. But then there will be future cases in which the provision is not so clear. That, I think, is the situation in the case of the 47 people who were prosecuted for conspiracy of subversions. I think the law is not clear, and how the court applies the law to this particular case is, I think, quite unpredictable. So there will be room for the court to apply common law principles or human rights principles in dealing with such cases where the law is not clear, that the language of the provision is not clear, unlike the language of the provision on bail or not granting bail. So secondly, there are some decisions among those which I've mentioned, which have far-reaching implications. For example, as Johannes has mentioned, the CFA decision on not to grant leave in the Waijing case actually contains a lot that may be relevant to future cases, because basically it affirms the approach of the Lee court in the Chongfeng case to the nature and scope and effect of NPCSC interpretations. Even though in the Chongfeng case, the court was talking about the 1999 interpretation, which is much narrower and much less activist than the NPCSC interpretation in 2016. So the Waijing case actually gives a lot of room for the future activism by the NPCSC in exercising its power of interpretation. And then on Cora's issue, whether there's bifurcation and so on, I think that different rights, can be dealt with, using slightly different approaches. For gender, transgender, or LGBT rights, these are rights relating to individual persons and their gender or sexuality. But then there are other kinds of rights, political rights. So I just mentioned that the King case, which Johannes also mentioned, on restrictions on the right to be a candidate in an electoral election, where a legislator has resigned his or her seat. This concerns a political right, and I think, as I already mentioned, the King case can be of far-reaching significance because basically it has enunciated some kind of political question doctrine, even though it did not refer to the US case law and political question. I think, Paul Jin, you have written an article on political questions. So in effect, even though the King case only applies the proportionality test and the margin of appreciation, in effect, it is adopting some kind of political question doctrine. So even in liberal jurisdictions like the US, there can be political question doctrines which which limit the court's activism in relation to certain kinds of political matters, including political rights. So that is my my brief response.
Thank you very much, Albert and Po-Jen. Simon?
Yes, just briefly, let me just refer to the second question first, which is the question of the Lee Court, Ma Court interpretive approaches. I think I see a lot of continuity. And I haven't really seen anything where, you know, the Lee Court did something and then suddenly the Ma Court is now reversing or changing gears. Not that I've seen in the criminal law cases. So their common law approach to interpretation is very much consistent, and you see a lot of sort of seeds that are planted in the Lee Court, and then they're, you know, they continue to sort of grow in the Ma Court. One thing I would highlight is one thing you don't see is, as I mentioned, Frischloff, you don't see a lot of dissent in the first place, but in the Lee Court there were 4 very prominent sort of dissents from Justice Bakari in criminal evidence, in the Leung Kwok Kong public assembly case, and they were you know, quite you know, vivid dissents. You don't really see that under the Ma Court. So I think one might say that Ma, it's a lot more of a unified court, you know, speaking and thinking in the same mindset. You don't see these great sort of debates amongst the judges. In fact, doesn't leave you a lot to write about, unfortunately. But that might maybe one sort of difference. NSL, I've written about this recently, but I think the court's approach to interpretation will be the really important deciding factor, because the court says they can't strike down the NSL for violating the basic law. But what it can still do is apply common law principles of interpretation, and they can apply and to see whether or not the NSL is actually a specific exception to any of the human rights norms. It can actually try to interpret the NSL provisions in a way to minimize the intrusion on rights. So there's still a lot of room, I think, for interesting common law interpretation arguments. Now, lastly, Cora's point about bifurcation, I don't think we see so much of that in the criminal cases. Firstly, you don't have a lot of constitutional right issues in the criminal cases. I said about 20% of the caseload. Secondly, in the common law principles still are quite, you know, dominant. And so there's still a lot for the court simply to refer to history, the comparative law, in order to just, you know, stay focused on legal issues, legal principles. And on sort of the politically sensitive cases, I mean, one might just use the example of the Raphael Hui case compared to the Donald Zhang case. You know, they reach different sort of ultimate results. It's not really comparable, but, you know, I think really they can just focus on the legal issues and sort of ignore the political sensitivity aspects. Finally, you said there's a lot of, very interesting cases in the lower courts. Someday I'm sure they'll get to the Court of Final Appeal. I haven't studied whether the CFA is being a bit too restrictive in granting leave. That would be a very interesting question. As I said, they're hearing fewer cases. Are they being a bit too restrictive on granting leave? I don't know. It'll be interesting to look at. But one thing I will say is that the Court of Appeal, of course, has very strong criminal law expertise. And we've seen changes in the vice presidency in the last decade. The court right now is very strong on criminal law. You have ex-DPPs, former defense lawyers serving on the court. So a lot of issues get well aired and decided in the Court of Appeal. They don't need to go up to the Court of Final Appeal.
Thank you, Simon. Thank you. Johannes?
I try to be brief. I think on question 1, it is too early to say how NSL affect the judicial or the public law legacy at this stage, as we have only 1 judgments from the Court of Final Appeal. But it is quite clear that the court operates in more difficult political environment. They are more constrained, especially when the NSL was drafted in a very different traditions, no matter in terms of style, in terms of language, and so on. I agree with my colleagues that it would be difficult, if not next to impossible, for the Court of Final Appeal or any court to strike down the provisions of NSL. But on the other hand, and I entirely agree with Simon on this, is that there are a lot of rooms for interpretation because NSL contains a lot of very vague language. And not only the vague language, some of the concepts, even within common law and what is seditions and so on, these are extremely broad and vague within the common law. So there are a lot of rooms for judges to tidy up the loose knots and tighten up the law there. And it is in this area, I think, creativity and innovations from both lawyers and judges will be extremely important, and guided by notably Article 4 and 5 of the NSL, which clearly preserve fundamental rights like presumption of innocence and ICCPR rights and so on. So these could be leveraged that the court could use to at least cut down or restrict the scope of some very draconian law. And whether that will happen to be the case, I think only time will tell. And I'm always skeptical when the court said the provision is clear. If the provision is so clear and unambiguous, the case will not go on appeal. And then it would be difficult to explain why the lower court would come to one set of decisions if the provision is so clear. And like the first Bell case, and the difference between the Court of Final Appeal and the divisional bench actually turns on the interpretations of a provision which contains double negative. Should double negative be turned into a positive statement, or should a double negative and unless be changed into only? And there are at least 2 to 4 different way you can interpret that provisions, and in that sort of situations, that come back to my earlier point, when the law could be ambiguous and when there could be more than one views to interpret the provisions, which one you adopt from time to time depends on certain values choice here. And I'm more critical of the Court of Final Appeals in the Waijing case, which I think that there could be alternative way of interpreting that. But then how far the court would remains innovative. And I think at this stage it's still early, especially when it comes to substantive offense, which may be more draconian, which may have a far-reaching impact on liberty of the person. On the values choice, etc., although Albert said that it is a political doctrine, I'm not denying the political doctrines arguments. The difficulty I've seen is it is not consistent. It is more political that a few legislators who has already been elected legislator and resign, and to allow them to take part in an election. Is it more political than to allow the entire prison's population to elect? I would have thought that the entire population of prisoners to elect is far more, has far more serious consequences than a few legislators to take part in the by-elections. And it is this kind of inconsistency that we are concerned, and the justifications are not at all convincing. Finally, on the issue of values choice, I think this is still a very early stage, and this is a huge subject which have been quite carefully studied elsewhere. But it has not been fully studied in Hong Kong as it involves some socio-legal studies. In the first place, I think it is important that the court recognize some of the choices are really hidden value choice, which the court may not even recognize, to lead or not to lead, and so on. Is it a political decisions, or is it a freedom of expression issues? The court may think that it is apparent, but then when you look at it more carefully, it might involve some kind of underlying value choice. How do we see these legislators resigning? How do we see the values of foreign domestic helpers? And so the first thing is to recognize it. The second thing is to be more explicit and be reflective on it. And once you become explicit, then people can discuss, and hopefully that would generate some consensus, or at least we understand where the judges stand. And which leads to a further point, which Pojin touched upon earlier on when you talk about Waijing Case, who is on the government and who is the junior, and then they happen all to be on the Court of Final Appeal. It touched on the point that I made earlier, is the lack of diversity, not only on the Court of Final Appeal, but also on the Court of Appeal and the Court of First Instance. There are a lot of studies about diversity among judges, particularly in UK, more so in US. Very few studies about the diversities among judges in Hong Kong. And although it has been pointed from time to time, some judges are pointed with a particular background, which they may tend to see things from a particular perspective. There's a lack of diversity. And this is something which can help the court to see things in a wider perspective. And not necessarily means that it is better, but then when there are more perspectives there, and especially for a court of final appeal, which are making important judgments, a wider perspective is certainly helpful. And Lady Hell, for example, is a lady judge would present on the final court, and when she deals with family case, children's case, she might see things very differently from her male colleagues already. And I think with a court of that importance, the diversity will certainly enrich the perspective of the courts.
Thank you very much, Johannes. And we've come to the end of this seminar. These discussions have been really stimulating. Please join me in thanking our speakers for their very rich and thoughtful and thought-provoking presentations. Thank you all for your questions as well, which has led to a very stimulating discussion. I think the consensus is like all the speakers agree that the Ma Court has shaped the public law jurisprudence of Hong Kong in important ways and have laid down approaches that will continue to steer the court through what will remain a turbulent time for Hong Kong. So this is a time both to celebrate the jurisprudence of the Ma Court as well as to reflect on its legacy. Thank you very much to all of our speakers, and thank you to you all for attending. Hope to be able to see you in future events of the Faculty of Law and the Center for Comparative and Public Law. Thank you.
Thank you.